interest that is most commonly held by the business and individuals. Number 6, example of duties, rights, and remedies of landlords, and duty, right, remedies of tenants in the agreements to lease the real property. Number 7, the difference between legal protections for tenants in commercial leases versus residential uses. Number 8, the difference between sublease and assignments. Number 9, 2 types of laws that regulate the use of real property. Number 10, the government rights, authority, and limit, and government, exercise, eminent domain power. This chapter overviews the categories of various types of property that is important to conducting the business. Number 2, levels of property, ownership right, responsibilities, and restrictions. Number 3, property law that governs the legal relationship between landlord and tenants. Number 4, the method that is used by the government to regulate the use of private property. Introduction. The legal concept of property is very, very important to understanding how property law provides foundation of our capital economy. What is the meaning of property? The property means something that may be owned or right or interest that allow a person, allow the owner to exercise dominion power over the things that may be owned or possessed. That is the meaning of property. Your appearance, your ability is your property, because that is the something that you have owned. Okay? 2 types of property: personal property and real property. Property is classified as a real property and personal property. Personal property is any property that is tangible and movable that cannot be classified under the definition of real property. In the business context, the goods, vehicles, inventory, equipment for a business operation, such as computers, are all examples of personal property. Rights of property ownership. Property ownership is a bundle of rights. Property ownership has a bundle of rights, consists of a bundle of rights that law recognized and enforced, whereby the title owner has exclusive control, exclusive possession, transfer, and use of the property. The ownership of the personal property may be acquired by productions, acquired by purchase, acquired by reason, gift, will, inheritance, and acquired by taking possessions of another person's property, etc. There are a lot of methods to acquire the personal property. Bound articles. A person who finds abandoned property, mislaid property, or lost property may or may not be the true owner. In that case, the finder of lost property obtains the title. Title means the ownership of the property is referred as the title. The title obtains, the finder of lost property obtains the title to the goods by possession. However, exception is the actual owner. Actual owner can take back his or her personal property at any time. Therefore, the finder must return the property when their true owner asks for his or her property. Good faith purchaser. The property law mentions all that a seller cannot convey the valid title unless the transferor has a valid title in the first place. Therefore, if a goods are stolen, the actual owner can recover his or her property even from a good faith buyer. Leased personal property of UCC Article 2A. UCC Article 2A defines the leased personal property. The leases or rental is governed by both principal property law and commercial laws. Lease agreements are the form of personal property contract and lease agreement are governed by two laws. First, governed by lease is governed by state statutory law that are modeled after the Article 2A of the UCC or common law, governed by common law. Real property, second category of property is real property. The law of real property concerns the ownership, concerns the acquisition, concerns the use of the land. Okay? Real property includes the rent and anything that is growing on the land, anything that is affixed to the land, anything that is incidental or appurtenant to the land, or anything that is built upon the land is the definition of the real property. Real property includes not only the land, but also anything that is firmly attached to the land, or that is firmly embedded in the land, are the real property. Real property includes, therefore, real property includes the buildings, trees, crops, other vegetations, water, groundwater, minerals, airspace above includes in the real property under the definition of the real property. Ownership right to the owner of a parcel of real property have a bundle of rights, bundle of legal rights that is associated with ownership. Ownership of land include ownership of land, ownership of structures that is built upon the land, as well as ownership of plant life and vegetation on the land. The ownership right of the real property includes use of land, enjoyment of land, subsurface right, water rights, airspace right. Subsurface right means landowners have rights to the soil, and landowner have right to any mineral, any oil, any natural gases among the soil that is referred as a subspace right. Water right means the landowners have a legal right to reasonable use of any stream water, reasonable use of any lakes water, reasonable use of any groundwater that are fully or partially part of their property. Airspace right is a use of airspace above the surface of the earth. Okay? There are 4 forms of ownership interest. These 4 common ownership interests are very, very important to the business ownership. First form. This form includes the fee simple ownership interest, right estate ownership interest, leasehold estate ownership interest, easement ownership interest. First, title ownership interest of land is estate in rent. Estate in rent. The term estate is used to describe the person's ownership interest in their property. Estate in rent are classified as either freehold estate or non-freehold estate. Freehold estate is known as a fee simple estate. Fee simple estate are the ownership interest of uncertain durations or indefinite durations. Non-freehold estate are those held by a person who lives in the rear of property. Freehold estate. Freehold estate is the most common forms of freehold estate. Freehold estate consists of 2 types. Fee simple freehold estate and right estate freehold estate. A fee simple estate is the absolute title to the land that is free of any other claims against the title. Life estate gives the person the right to possess, to use the property for a time measured by his or another person's lifetime. Is referred as a life estate. You must distinguish between the right fee simple estate and right estate. There are 2 types of fee simple estate. Fee simple absolute estate. Fee simple divisible estate. Real property terminology is very difficult for the student because American real property comes from the ancient England law under the king's feudal system. Therefore, there are a lot of unfamiliar terminologies. What is the fee? Fee simple absolute state. What is the fee? Fee is the England king's original territory. Is referred as a fee. This king's territory can be conveyed to his knight, kings. His territory, some territory, to his knight. In return, the king asks for a knight's royalty and asks for the money. That is referred as the fee. Okay? Therefore, there are two types of fee simple. Simple means the highest. Okay? Two types of fee simple. Fee simple absolute. Fee simple divisible. Fee simple absolute is a normal concept of a full ownership of the land. Fee simple absolute is the highest level of ownership of the property. Fee simple absolute property is fully 100% divisible, 100% divisible, 100% inheritable, with indefinite durations, permanently. Also, fee simple absolute must be fully alienable. Alienable means the separate. There is no direct restraint on the transfer of the ownership of the simple absolute estate. Second type of fee simple estate is a fee simple divisible. Fee simple divisible is a fee simple right when with certain restrictions. The violation of fee simple divisible estate resulted in the property ownership is automatically reverting to the original owner. Example, I will sell my land to you, but you can use my land only for the purpose of the religious or educational purposes. However, the buyer, assume that the buyer used the rent for the business purposes. In that cases, the rent is automatically reverted to the seller. That is the fee simple divisible property. A life estate is the second category of estate. Life estate is simply ownership interest that lasts only for the lifetime of a specified person. Okay? Example, I give you my house, but you must take care of my elder mother. Okay, and you can use my house during the life of my mother. If my mother died in the future, how my house will automatically reverted to me, original donor. That is referred as a life estate. The person who has a life estate interest is known as life tenants, because life tenants may not sell, may not pledge, may not convey the building in any way during the ownership. Okay, that is life estate. Or life estate divisible is a life estate with the restrictions that is attached in some way. If you do not take care of my mother, I will take my home. I will take your home. That is a life estate divisible. Okay? Leasehold estate, another type of estate is a leasehold estate. A leasehold estate is a ownership interest that is provide the least amount of property right, because leasehold estate grants only a qualified right to use the real estate only for a limited time period. The most common form of leasehold estate is the landlord tenants agreements. This is the most common form of leasehold estate. Okay. The laws, the statute laws that is governing the landlord and tenants. A lease or a rent is an agreement between a landlord and the tenant for the rental of real estate. The source of law that is governing the rental rent range from state statutory protections of residential tenants to common law principle governing certain contract. This law is likely to offer more protections to the tenants, to the residential tenants than the commercial tenants. Okay? More protect than residential tenants, less protect to the commercial tenants, because a certain level of business and legal acumen is inputted to the business owner and business managers. Landlord rights and remedies. Landlord can keep any security deposit held by the landlord, and the landlord has a legal right to evict. Evict means the remove the tenants with cause and without cause. Tenants remedies In the cases of a violation of the tenant's rights, the tenants can either terminate the lease and sue against the landlord for his or her damages. Sue against the landlord for the tenant's damages, or the tenants continue the lease and recover the damages. Two types of remedies for the tenants. Tenants' duty. Tenants must pay the rent. Okay? Agreed upon the contract, rental contract. And tenants must act reasonably in care and use the property, rental property, in the due care, carefully. If tenants use the property unreasonably, in that cases, the landlord decrease your security deposit. Security deposit is normally 2 months the rental fee. Assignments and subletting. If the tenants want to transfer his tenant's interest to a third party for the entire remaining length of the rental term, this is called as an assignment. If the tenants transfer anything less than the remaining term, that is known as a subleases. Okay, the difference between assignment and subleases, you must distinguish. Regulations of commercial land uses. The state government and the local government frequently established the statute, established the ordinances that impose the regulation of land uses on how a landowner may use a particular part of real estate. That regulation of land use includes the zoning ordinances and the environment regulations. I'll tell you the zoning ordinances and environmental regulations in subsequent slide. Acquisition of real property. The title, ownership to the real property can be acquired by the purchase, acquired by gift, acquired by will, or inheritances, or acquired by tax sale, and the adverse possession. The adverse possession is a new terminology for the real property. The adverse possession is occurred when a person, not a true owner, non-owner person, wrongfully occupy the land, and non-owner act in a hostile manner and act in an open and hostile manner as if he was a real owner. In that cases, the true owner must take a step within a statutory time limit within 5 years to evict, to eject the non-owner's possessions from the land. You must remove my property. If the true owner does not take steps, in that cases, the true owner forever lose the right to eject the possessor, or in some state, the true owner can take the ownership of that other person's property. Okay? The law does not protect the idle, the negligent persons. The sales of real property. Sale is the most common way for real estate to be transferred. Most common way for real estate to be transferred is through the sale. The seller and buyer typically will agree on the essential terms such as the price and the terms. Okay? Seller and buyer must agree on the essential terms about the purchase and enter into the purchase of real estate. Ownership and the title. The title, what is the meaning of a title? The title represents the documents of the ownership. Title represents only documents of the ownership. What is a deed? Deed is a document that transfers land ownership to the buyer, to the third person. Okay? Title, deed is a different concept. Okay? What is the title ownership registrations. Registrations of deed in the recording office in the county government's evidences the ownership and the title that is putting your right on the public notice. That land is my land. Therefore, the third person, if third person cannot buy the specified or noticed property, that is the meaning of registrations. The deed. The deed is the most important documents in the sale of real property. The deed is a written instrument that transfers the title from one person to the other persons. A valid conveyance of real property is occurred through the execution of the deed and the delivery of the deed. Three types of deed. There are three types of deed: quitclaim deed, warranty deed, grant deed. Quitclaim deed conveys whatever title the owner, the grantor, has at the time the true owner executes the deed. Quitclaim deed contains no warrant of the title. Warranty deed contains the covenants of warrant about the title. There are two types of warranty deed: general warranty deed, special warranty deed, grant deed. In the grant deed, the grantor represents that he owns the land, but makes no covenants. That is the grant deed. Recording statute. A recorded deed operated to provide. A recorded deed is operated to provide the public with a notice of grantee's property interest, notice of buyer's property interest. The deed is recorded in the county's recording offices. There are three types of recording statute: race statute, notice statute, race notice statute. Under the race statute, in some state, first recorded buyer who recorded deed to the some tract of land has the superior title. Okay? First recorded buyer has the highest power, highest the priority under the notice statute, or rather grantee of property have superior title if, in the cases, his interest acquired without notice of earlier buyer's claim to the property under an unrecorded deed is a notice statute. Under the race notice statute, the grantee has the superior priority in the two cases. Okay, the grantee with priority is the one buyer who both takes his interest without notice of any other persons prior recorded claim, or the grantee recorded first. Okay, only that person has the highest priority in the land under the race notice statute. The method of assuring the title. In a title opinion, the attorneys examines the abstract of title and attorneys gives opinion whether grantor, the seller, has a marketable title or not. The attorney gives the opinion to the buyer whether the seller has a marketable title or not. Marketable title is a title that is free from the defect of the title, or that is free from the reasonable doubt about title's validity. The abstract of title means the history of what public records shows about the passage of time to the real property and show the other interest in that real property. That is the abstract of the title. Abstract of title does not guarantee of good title. Method of assuring the title. Under the Torrance system of restorations in some few states, the owner who owns the land impede a simple obtains the certificate of the title from the court. Court issues the certificate of the title, and the fee simple, the owner of fee simple estate requested The purchasing, the policy of a title insurance campaign is preferred and purchased. The policy of a title insurance is the most common means of protecting the title to the property. Title insurance obligate insurer, insurance company to reimburse insured persons. Okay? The buyer of the policy is referred as insured. Title insurance obligates the insurer company to reimburse the buyer for losses, certain damages, if the title proves defective. Okay, special application of the real property. First type, easement. What is the meaning of easement? The easement praises the particular use of land behind the exclusive legal fences. The easement is a legal right to make certain use of another person's property. Okay? A common example of an easement is a grant by the property owner to the utility company, to the water company, to the electricity company for the privileges to install the gas line or to install the water line and maintain the gas and the water lines. These easements may be acquired by the grant, reservations, prescriptions, or implications. This slide shows, this photo shows the power cables that require the easement. Utility easement are express easement that is granted by the written deed. This expressed grant of the easement is normally under the control of statute of Prof. Therefore, it must be in writing in order to be enforceable. The other type of easement are enforceable despite the lack of writing. Another special application of the property is the bailment. Bailment. What is the meaning of bailment? Bailment is created when the bailer, owner of the property, is referred as a bailer. Bailer entrusts the bailee to temporarily hold the property, usually for the two parties' mutual benefit. Example of bailment is a bailment of car, valet parking. Valet parking is the example of bailment. Bailment of car to valet means that the car placed into another person's possession to be, but this car must be returned to the owner in the future. Okay? In abatements, although a possession does not gain title by a possession, however, non-owner is still a rightful possessor of the goods. Okay. Another type is render's security interest. Security interest is a legally protected property interest. This security interest is created by agreement over the property to secure the performance of the obligations, usually the payment of the debt. Especially security interest in the land is generally referred as a mortgage. Mortgage. If you want to buy your dwelling houses, you must borrow the money from the bank. In that case, the bank have a security interest to your home. That is referred as a mortgage. Under the recording statute, the security interest must be registered in the county's recording office in order to put the public on the notice, public persons on the notice as to the existence of the security interest. Exercise the property interest include the foreclosure right of redemptions, especially the foreclosure, the result of foreclosure. Foreclosure resulted in the deficiency. In that cases, the mortgagee is a render, the creditor, bank, referred as a mortgagee. Mortgagor is a buyer of a home, borrower, buyer of a home, borrowing money from other persons, other institutions, is referred as a mortgagor. You must understand the difference between mortgage, mortgagor, mortgagee. When you buy your car if you cannot give the dealer, car dealer, the full amount of money, in the cases the bank borrow you the money. In the cases the bank has a security interest in your car, okay, and the bank is referred as a mortgage Z. You are referred as a mortgagee. Okay? The mortgagee, the bank, can sue landlord for the deficiencies as a result of the foreclosure. Foreclosure means the public auction is referred as a foreclosure. The security interest transactions in the personal property. There are two types of security transactions. Security transaction in the real property, security transaction in the personal property. Security transaction is a transactions in which the lender acquires the security interest in the collateral, in the pledge owned by the borrower, and this security interest is entitled to foreclosure, public auctions, or repossess the collateral in the event of the borrower's default. Default means that do not have an ability to pay the borrowing money. Security transaction also applies to the personal property. Sale of the personal property can be secured by way of security interest according to the Article 9 of UCC, Uniform Commercial Code. These security interests can serve as collateral in a sale of that personal property, such as the security interest that a bank may take in your purchase of your new car. A valid security interest in the personal property is realized at the moment of attachment as defined under the Article 9 of UCC. Okay. There are a lot of unfamiliar terminology in the property. You must understand these unfamiliar terminologies. Okay? Attachment, security interest, perpetual is a new terminology. What is the attachment? The attachment is a legal process by which the court, the judge, at the request of the creditor, at the request of the bank, the court, the judge designate specific property owned by the buyer, owned by a debtor, to be transferred to the bank in the event of default. What is the meaning of perfections? Perfection is happen when a financing statement is filed. Thereby, perfection is putting the third unknown parties on the notice of the existence of the security interest. The priority problem is arised. Priority among the completing the security interest when more than one party claims a security interest in the same collateral, a protected security party's interest has a priority over the interest of most other parties. Or limitations of the property. Okay, the property, private property has a limit. You cannot have an absolute power over your home, over your property. The private property right is always under the control of other person's right, legal right. The private property gives ways to the common goods of our society, such as the nuisance, eminent domain, taxations. What is the nuisance? The society, under the nuisance law, our society, the government imposed the duties on the landlords by nuisance law, zoning law, eminent domain laws. What is a nuisance? Nuisance refers to the lawsuit that may be filed if a property is used unreasonably. Property use unreasonably interfere with other person's ability to use or ability to enjoy her own property. In that cases, the neighbor can sue against the true owner under the nuisance law because the neighbor owner interfere my enjoyment of my property. Eminent domain. What is the eminent domain? The authority, the power of the state government, the power of the federal government. The state government and federal government has the power to take the ordinary person's property, private property, that is referred as the eminent domain power of the government. This eminent domain power is derived from the Fifth Amendment. The local government is exercising its police power to advance legitimate objectives of the municipality as a whole. The Supreme Court has recognized this police power, but Supreme Court, Federal Supreme Court has also set some limitations on the government's control of private property. That is the zoning ordinance. Limits on zoning regulations. The courts have ruled that the law set some limitations on the local government's power to regulate private property usage through a variety of U.S. constitutional protection of property owners. environment regulation is the limitations of the private property. Okay. The government can impose environmental based on land use or regulations, so long as the government advanced some substantial state interest. The courts have generally held that the wetland and coastland preservations ordinances that restricted the owner's right to develop, owner's right to clear or dredge the land are the legal use of government for this power. Taxations. The government has a certain taxing authority, taxation power. This taxation power supersedes the property right to some extent. The taxation is necessary to fund the public purposes, and tax is necessary to promote the general welfare, such as the road constructions, educations, law enforcement, the courts, operations, and national defenses. For this general welfare, the government has the power to levy the taxes. The Article 1, Section A of U.S. Constitutions gives the federal Congress the power to raise the taxes, to collect the taxes, the duties, imposts, and exercise. Income taxes was introduced. Article 1, Section A of U.S. Constitution introduced the federal taxation. However, under the 16th Amendment to the U.S. Constitution's income tax was introduced. According to the 16th Amendments, the state government also have a power to levy and collect the tax from the residents. Duration limitation of property. Not all property is property forever. Example, patent law, copyright law has a limitation, property limitations. The patent and copyright law are limited only for limited times. The patent is generally granted for 20 years. The copyright protections generally rest for 70 years after the death of the author. Rule against the perpetuities. Rule against perpetuities prevents multi-generations control of one's proper interest. Rule against perpetuities established that an owner cannot legally control what belongs to her beyond the right in being plus 21 years. Okay? Lives in being plus 21 years is a maximum control limitations. This rule restricts the duration of the true owner's exercise of exclusive right over the resources to a duration of true owner's rights in being plus 21 years in order to prevent the true owner from controlling the resources through the many future generations by setting up first arrangement for extended duration. That is the rule against perpetuities. Okay, I finished the lecture. Okay. Some to test for your knowledge. Okay, true or false. A person who finds abandoned property may claim ownership. True or false? True. A conditional gift is not the gift. True. Tom found the textbook on the desk. That textbook has Smith James written inside the cover. Tom, the finder, Tom, has the right to sell the textbook. False. The personal property may be classified as tangible property, intangible property. True. Okay, a document or title refers to the documents that identify the ownership of the property. True. That is the definition of the title. Okay. A shipping document such as the UPS is held only to the slight duty of care. False. The highest duty of care. The UPS man has the highest duty of care. Okay. Bailment is a contract. True. Okay. Accession means mixing property on, not mixing property. Accession means the fixed property owned by the several persons, so that property cannot be separated and ownership is determinated. Okay. For his two daughters, Brad built the door canal and the lawn wood posts and wire fencing behind his houses. When Brad sells his houses, the canal is the fixed that belongs to the real property. True. Okay. True. Song as drainage ditch behind house that is described in the written deed. The song is not permitted to change the ditch in any way. That drainage ditch is easement. True. Implied warrant of habitability guarantees that the house has no hidden defects, rendering it